and re-asked in exactly the same format. Again, that is not correct, my Lord. The prayer we seek this morning, my Lord, and as the senior counsel said, on a very limited basis, is at its stage was prayer number 3, no, was prayer number 2, and today is prayer number 4. It is specific to proceedings at the Senate on the 16th, 17th, and 18th of October. That prayer was not one of the prayers in case number 522. Secondly, my Lord, we are told that the grounds are the same. You are referred to public participation and standing order number 64. There are many things to say about those things. For example, public participation. My learned senior referred you to the results, alleged results for KU South, and the fact that spirits participated in that process, 162%. That was not in the first petition, because this occurred after. So even though public participation is still an issue in this petition, there are different issues about that public participation, my Lord. Secondly, standing order number 64, which my learned friends have made heavy weather of, also has the question about whether the Speaker addressed his mind to the threshold test when he said that it is precise and all particulars are covered. That is in the new petition, not in the old petition. But apart from that, my Lord, I am told I'm too fast, my Lord. I'm very alive to the time, sorry. But let me go a bit slower. My Lord, apart from that, the question of the new issues, even on some of those other issues, in the motion, on the face of the motion, under the grounds, ground number D, capital D, lists 10 substantive issues that the motion seeks, no, that the petition seeks to impeach as regards the process at the National Assembly. 8 out of 10, my Lord, all concern the process after the National Assembly voted. Including, my Lord, because I'll be addressing this shortly, the fact that the entire impeachment process has been designed to avoid and to be ring-fenced from judicial scrutiny and accountability. It's one of the 8 out of 10 I am saying, my Lord. And so again, it is not true, because my good and learned friend, Mr. Nyamodi, and I concede, English came with a sheep, so I read it to his work before me. The word identical means similar in all ways. 522 and 525 are not similar in all ways, my Lord. They're very different. Thirdly, my Lord, you are told there was a lot of heavy weather made of the fact that we should allow the Senate to first conclude its work, and I believe my good friend Mzanja here said that the Parliament must be seen as one on all issues. My Lord, the Constitution at Articles 95, Subarticle 5, lists the specific, at Article 95, Subarticle 5, lists the specific role that the National Assembly plays in an impeachment process, unique to itself, not to be shared with anybody. Article 96.4 lists what the Senate does. There are 2 distinct functions in this process, which is why my learned senior said this is a 2-stage process. And the thing with the 2-stage process, my Lord, is that if stage 1, the National Assembly, has conducted a constitutionally invalid process, as we argue it has, then the words of Lord Denny in the case of Benjamin McFoy versus United Africa Limited, which is number 1 in our bundle, and I leave it here, my Lord, are most apt, and this is what they say. If an act is void, it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order of the court to set it aside. It is automatically null and void without more ado, though it is sometimes convenient to have the court declare it to be so. And every proceeding which is founded on it is also bad and incurably bad. You cannot put something on nothing and expect it to stay there. If the National Assembly conducted an invalid exercise, it stands on nothing. Nothing can proceed to the Senate because nothing can stand on nothing. My learned friends have made heavy weather of the constitutional timelines, my Lord. But when my Lord retires and looks at Article 145, you will find that they have hamstrung themselves. They seem to have some deadline only known to them, which doesn't allow them the period the Constitution allows them. They give themselves 2 days for a period the Constitution allows 7 days. They give themselves 1 day where they're allowed 10 days. They are looking for a microwave impeachment, my Lord. So they're constricting their own timelines so that they can come and tell you there is a timeline problem. My learned friends seem to have misunderstood what I was saying about the Kirogoya order and the public participation. What I was saying is that the Kirogoya court directed the Senate to also conduct public participation expressly. The Senate has then produced a calendar that does not include public participation, although I now understand it a bit more clearly, because I think Ms. Tangi's position is that the Senate does not in fact require to do public participation, in spite of Article 10, in spite of Article 118, and in spite of the court's order. My learned friends say there's no prejudice. My Lord, there's tremendous prejudice. Once the process is concluded unconstitutionally, my Lord, not only does my client's role as Deputy President cease, but my Lord, in accord with Chapter 6, he can no longer serve in any capacity as a public servant from that day on. He stops being a public servant for all time. His Article 38 rights are taken away, and he cannot even return to his former position as the DO for Navajo in Kakamega. That is the prejudice, my Lord. He, of course, ceases to be Deputy President. But on this question, my Lord, that you should wait until the Senate has resolved the matter, my friends are blowing hot and cold. They are approbating and reprobating. When my Lord retires and has time to review the preliminary objection raised by my good friend Mr. Bumbo, objection number 3 is that Article 165, Article 3C, precludes the High Court forever, once the Senate has made its decision, from reviewing that decision. That is their position. They say the High Court can never review what the Senate does. So in a sense, they're being clever. They're telling us, twende kichinjio, then afterwards they say, you cannot argue with what kichinjio did. Ground number 4 of my good friend Mr. Kuyoni's grounds of opposition is in similar terms. Again, the High Court has no jurisdiction to hear or determine a dispute relating to the removal of a president or the deputy president from office on the grounds of incapacity. And this, my Lord, is what I was addressing. They are saying that 14 million Kenyans, pursuant to Article 1 of the Constitution, in one of the most expensive presidential elections in the world, can convene as they did on the 4th of August 2022 vote, the National Assembly and the Senate can then remove the president, and the High Court cannot question that decision. That is the real weight of what you're being asked to do here. You are, in a sense, almost being asked to adjudicate and direct an order for a parliamentary dictatorship. My Lord, you are asked, my good friend Mr. Wanyama said that we are on uncharted ground. We don't know what will happen if you give a conservatory order. My Lord, we do. They will comply. That's what we do when we get court orders. We obey. That's the consequence of a court order. That's number one. But number two, if my Lord is minded to grant a conservatory order, and we beseech you, my Lord, this is one of those occasions when the court ought to intervene in a matter that is so unconstitutionally conducted. But if my Lord is minded to give the conservatory order, all it will do is suspend a process which will then resume in the unlikely event the petition is dismissed. My good friend Mr. Milimo has said, together with his colleagues, public participation was conducted. My Lord, only this court can fully interrogate that question. As Justice Mugambi said, I will not say too much more of that. I think Justice Mugambi's orders were. Justice Matter case, my Lord, this case of Justice Matter, number one, it dealt with ex parte orders. It was not dealing with inter party orders like we are here. That's number one. Number two, again, what had happened was that then Governor Wambora had gone to court before the County Assembly had debated. And when you read it, you can tell the context. So there was no debate. County Assembly had not debated. So it's very different from this case here. Here we have a right decision of the National Assembly issued pursuant to Article 95. And that, my Lord, well, I'm on it, is the same thing with this case of Mwangaza, which my good friend Stanji has referred you to. When you read paragraphs 1 and 2 of the Mwangaza decision that was given to you from the Court of Appeal at Nyeri sitting in Meru, you will find that Governor Mwangaza had gone to court before the debate began. As soon as she got a notice, she went to court, and that's what the court is addressing. The court is saying you must allow the County Assembly to debate the issue. You are told, my Lord, that you must avoid conflict and crisis and exercise judicial restraint. The entire reason courts exist, my Lord, is to adjudicate on conflicts. You cannot be asked to avoid that which you are set up to do by the Constitution. You are told again about the time limits, and there was some parallels drawn to a presidential petition under Article 140. My Lord, there's a very distinct difference. Article 140 deals with the highest court of the land. There is no appeal before it, after it. And which is why some of those timelines had to be put. But I must say, I am aware on numerous occasions now, and I think during the various constitutional amendment processes in the last 2 years, I know for a fact the judiciary itself has written a memorandum requesting that that period under Article 140 be extended. You are told, my Lord, again, that there are no guidelines on what happens if the court grants these orders. And Mr. Wanyama is right in one way, my Lord. For example, it's unclear, and one of the petitions I've seen filed raises a very interesting question. Do you need the IEBC to be in place before you can replace a deputy governor? That's one of the questions that has been asked. So there are many questions of this nature that to be asked, but the solution is not to hurry, to go over the cliff. It is to first wait, so that you're certain about what you do. My Lord, you are told again about public interest. Justice Mugambi dealt quite at length with the public interest and found that there is overwhelming public interest. But you are told, my Lord, that again, why don't you wait for the Senate and go and test these grounds? One of the grounds we've raised in this petition, my Lord, is that the debate is that the motion debated in Parliament is not the same one that the Honorable Mutuse filed. And we've attached for you in our submissions, my lord, and in the petition, a table from Hansard showing that, for example, one MP said that Honorable Gachagua lacks education. They discussed many other things other than the 11 grounds. One asked why the lawyers are getting fees. So, my lord.
My lord, I thought we can raise an objection. He's replying on issues that we
I have abandoned that issue. I have abandoned that issue. I did not get into the question of the matter of the night debated. My lord, you are told 282 members of parliament have voted, and therefore you should not interfere with the decision. My lord, the Kenya Law Reports website has now a dedicated page for statutes that have been declared null and void and struck out by the same parliament for failure to public participation. This court has been ordered. We've been asking it to do. The good friend Mr. Milimo. I'm not sure, Mr. Milimo. I think I've addressed everything on it. My lord, allow me to close my submissions by pleading with you to grant the orders we have sought, the conservatory orders we have sought. Until, my lord, the three-judge bench can be constituted. As we speak here, it's not been constituted. And to clarify a matter, my lord, we are not before the Senate yet. We are not yet before the Senate. It has a calendar, but it's a calendar that's unconstitutional.